What's your business in the VIP lounge? People like you can't afford it.
Why are you touching me like that?
Keep your voice down. Give me the ID or you're not getting past this checkpoint. You make one wrong move, I'll have you detained.
Just harass a federal lawyer. Think about that before you take another step.
The security camera footage would later show exactly what happened that August 19, 2024. Officer Daniel Mercer had only 7 months on the job when he destroyed his entire future inside Miami International Airport for absolutely nothing. He saw a black woman in an executive dark blue suit entering the VIP priority boarding queue. No crime, no alert, no threat. But in Mercer's mind, that was enough. Emotion replaced training. Bias replaced procedure. Suspicion replaced law. That black woman was attorney Breanna Lewis, a respected federal DOJ lawyer who spent nearly 2 decades holding police departments accountable in federal courtrooms. What happened next would detonate national outrage, force congressional commentary, and ultimately cost this rookie cop $30 million. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Miami International Airport processes over 45 million passengers annually. It's a sprawling complex of terminals, gates, security checkpoints, and retail spaces that operate with mechanical efficiency. On any given day, thousands of travelers move through its corridors, business executives, tourists, families, students, all flowing through the standardized rituals of modern air travel. August 19, 2024 was unremarkable by airport standards. The morning shift was routine. Flights departed on schedule. Security lines moved steadily. The air conditioning fought against the Miami heat that pressed against the terminal windows. Officer Daniel Mercer was assigned to Terminal D that morning. He wore the uniform of the Miami-Dade Police Department's Airport Division. 7 months into the job, still in his probationary period, still learning the rhythms of airport security, the jurisdictional boundaries between local police and federal TSA, the protocols for responding to actual threats versus perceived irregularities. Mercer was 25 years old. His academy performance had been adequate but unremarkable. His field training reports noted a tendency toward overconfidence that didn't match his limited experience. His supervisors had flagged concerns about his judgment in ambiguous situations, a preference for action over assessment, intervention over observation. But none of that had prevented him from receiving a badge, a weapon, an assignment to one of the busiest airports in the United States. Mercer stood near the VIP priority boarding queue for Gate D12. The queue served first-class passengers and airline loyalty program elite members. It was shorter than the main boarding line, moving faster, occupied by travelers who carried themselves with the assured posture of people accustomed to preferential treatment. Attorney Breanna Lewis approached the VIP queue at approximately 9:47 a.m. She wore a tailored dark blue suit, executive cut, professional. Her carry-on bag was leather, wheeled efficiently behind her. Her boarding pass was already pulled up on her phone. Everything about her presentation communicated competence, purpose, and belonging. Lewis was 43 years old. She had spent 17 years with the Department of Justice's Civil Rights Division. Her specialty was police misconduct litigation. She had prosecuted cases under 18 U.S.C. Section 242, criminal civil rights violations committed by law enforcement officers. She had secured convictions against officers who had used excessive force, conducted unlawful searches, and violated citizens' constitutional rights under color of law. She knew the law. She knew police procedures. And she knew exactly what lawful authority looked like and what it didn't. Lewis was returning to Washington, D.C. from a 3-day conference in Miami, focused on prosecutorial strategies for addressing systemic police violence. She was tired. The conference had been intense. Panel discussions, case reviews, strategy sessions that stretched late into the evening. She just wanted to board her flight, settle into her seat, and decompress during the 2-hour journey home. She stepped into the VIP queue behind 2 other passengers. She glanced at her phone, checking the time. Boarding would begin in 15 minutes. Officer Mercer watched her join the line. Something shifted in his posture. His head tilted slightly. His eyes tracked her movement with focused attention. The security camera footage from the terminal would later capture this moment, the exact second when Mercer decided that Lewis required investigation. She hadn't run, hadn't looked around nervously. hadn't exhibited any behavior that would constitute reasonable suspicion under Fourth Amendment standards. She was simply standing in a queue designated for first-class passengers and airline elite members. But in Mercer's assessment, that required explanation. The internal justification loop that occurs in these moments is rapid and largely unconscious. The officer sees something that doesn't match their expectations. Their brain searches for explanations. Bias provides the easiest narrative. This person doesn't belong here, which means they're probably doing something wrong, which means intervention is justified. It's circular reasoning, but it feels like logic to the person experiencing it. Mercer left his position and walked toward the VIP queue. His stride was deliberate, purposeful, the body language of someone who has decided that action is required. Lewis noticed him approaching. She looked up from her phone with the neutral expression of someone accustomed to navigating public spaces. Not concerned, not alarmed, just aware that a police officer was walking in her direction. Mercer stopped directly in front of her, blocking her position in the queue. "Excuse me, ma'am," he said, his tone carrying that particular blend of false courtesy and implicit challenge that officers use when they want compliance without having to explicitly demand it. Lewis met his eyes. "Yes, officer. Can I see your boarding pass and identification?" It was phrased as a question, but the expectation of compliance was absolute. Lewis' expression shifted slightly, not to anger, not to fear, but to recognition. She had prosecuted cases that began exactly like this. She knew the pattern. "Is there a problem?" she asked, her voice professionally neutral. "I'm conducting a security check," Mercer replied. "A security check of what?" "I'm standing in a designated boarding queue for first-class passengers. I haven't violated any airport policy or security protocol." Mercer's jaw tightened fractionally. He wasn't accustomed to having his authority questioned, especially not by civilians, especially not in the first 15 seconds of an encounter. "Ma'am, I need to see your boarding pass and ID. Now." The now was the tell. The moment where request became command, where the pretense of voluntary cooperation dissolved into demand. Lewis calculated her options. She could comply, hand over her identification, let this officer run his checks, endure the humiliation of being singled out in front of other passengers, accept the violation and move on with her day. Or she could assert her rights, require this officer to articulate legal justification, force him to operate within constitutional bounds. She had spent 17 years at the DOJ teaching officers that citizens have rights, that authority requires justification, that the badge doesn't grant unlimited power, and she refused to surrender those principles just because she was the one being targeted. Is this where bias becomes a pretext to manufacture suspicion? "Officer, on what legal basis are you requesting my identification?" Brianna Lewis asked, her voice steady and clear. Daniel Mercer took a small step closer, narrowing the physical space between them. It was a dominance technique. Subtle but deliberate. Use proximity to create pressure. Make the target feel uncomfortable. Increase the likelihood of compliance. "I don't need to explain myself to you," Mercer said. "Airport security. That's my basis. Airport security handled by TSA is located at the security checkpoints," Lewis replied calmly. "I've already passed through federal screening. I'm now in a secure area of the terminal, standing in a designated boarding queue. You're local law enforcement, not TSA. So I'm asking again, what specific security concern justifies this stop?" Other passengers in the VIP queue were watching now. The interaction had captured attention. Phones were being pulled from pockets. The moment was being documented. Mercer's face flushed slightly. He was being corrected, publicly, by someone who clearly understood jurisdictional boundaries better than he did. "Ma'am, if you don't cooperate, you're not getting on that plane," he said, his voice harder now. "Cooperate with what? You haven't articulated any lawful basis for this encounter." Mercer reached out and grabbed Lewis' arm just above the elbow. Not violently, but firmly. A physical assertion of control. Lewis pulled her arm back immediately. "Do not touch me. I'm conducting a security search," Mercer said, reaching for her again. "You have no authority to conduct a search. I haven't consented. You haven't articulated reasonable suspicion. And you certainly don't have probable cause." But Mercer wasn't listening anymore. He had committed to the encounter, had asserted his authority, and now he needed to follow through or risk looking weak in front of witnesses. He grabbed Lewis' arm again, this time with both hands, and began patting the sides of her suit jacket. His hands moved across her shoulders, down her arms, along the sides of her torso. It was invasive, humiliating, and completely unlawful. Lewis stood rigid, her arms slightly away from her body, not resisting physically but clearly not consenting. Her face showed shock mixed with outrage. Her voice, when she spoke, was controlled but sharp. "You are conducting an unlawful search. I am a federal attorney. I am explicitly telling you that you do not have my consent. You are violating my Fourth Amendment rights. And you are doing it in front of witnesses." Mercer's hands moved to the pockets of her jacket, patting them, checking for what? He hadn't articulated what he was searching for. Weapons? Contraband? Evidence of a crime that didn't exist? The search had no objective. It was pure performance. An assertion that he could touch this woman's body because he wore a badge and she had questioned his authority. "Why are you touching me?" Lewis asked, her voice rising slightly now, emotion breaking through the professional composure. "What crime do you think I've committed? What are you looking for?" Mercer didn't answer. He stepped back, having completed his invasive pat-down, and looked at her with an expression that suggested he had been perfectly reasonable and she was the one making this difficult. "Your boarding pass and ID," he repeated. The passengers in the VIP queue were openly recording now. Multiple phones, multiple angles. The gate agent at the desk was on her communication device, likely calling a supervisor. The encounter had escalated beyond what anyone had expected. Lewis' hands were shaking slightly, not from fear, from fury, from the violation of having her body touched without consent by someone who believed a badge granted him that right. She had prosecuted officers for this exact conduct, had argued in federal court that unlawful searches violate fundamental dignity, had secured convictions and settlements for victims who had experienced what she was experiencing right now. But intellectual understanding and personal experience are not the same thing. The violation felt different when it was happening to her. Should a citizen ever have to explain basic bodily autonomy to a trained officer, to understand why Officer Mercer's conduct was unlawful from the moment he touched Brianna Lewis? You need to understand the jurisdictional boundaries that govern airport law enforcement. Transportation Security Administration officers, TSA agents, operate under federal authority. They conduct security screening at designated checkpoints. Their authority is limited but specific. They can search passengers and their belongings as a condition of entering the secure area of the airport. This is considered an administrative search, and by presenting yourself for boarding, you consent to it. But once you pass through TSA screening and enter the secure area of the terminal, that authority ends. You've been cleared. You're in a controlled space where everyone has already been screened. Local law enforcement officers assigned to airports, like Officer Mercer, operate under different rules. They're governed by the same constitutional standards as any other police officer. They need reasonable, articulable suspicion to conduct an investigatory stop. They need probable cause to make an arrest. And they need either consent, a warrant, or an exception to the warrant requirement to conduct a search. Officer Mercer had none of these things. He approached Lewis without reasonable suspicion. She hadn't committed any crime. She hadn't exhibited any suspicious behavior. She was standing in a designated queue for first-class passengers, which she had every right to do. He demanded identification without legal justification. Simply being in an airport doesn't eliminate your Fourth Amendment rights. Officers can't demand ID from passengers who have already cleared security and are waiting to board unless they have specific, articulable facts suggesting criminal activity. And he conducted a physical search without consent, without a warrant, and without any legal exception that would justify touching her body. This wasn't a Terry frisk for weapons. Mercer didn't articulate any belief that Lewis was armed and dangerous. He didn't claim to fear for his safety. He simply decided that her refusal to immediately comply with his demands justified putting his hands on her. Under Fourth Amendment case law, this is unequivocally unlawful. The Supreme Court has held repeatedly that the government cannot conduct searches without individualized suspicion. That bodily searches are among the most intrusive forms of government action. That consent must be voluntary, not coerced through the implicit threat of force. Mercer violated every one of these principles. But here's what makes this case particularly significant from a legal perspective. Unlawful searches often multiply liability risk faster than even violent force cases. When an officer uses excessive physical force, The legal analysis focuses on whether the force was objectively reasonable given the circumstances. Courts give officers some leeway in rapidly evolving situations where split-second decisions are required. But unlawful searches don't happen in split seconds. They're deliberate, calculated. The officer has time to think, to assess, to consider whether their actions are legally justified. Mercer had time. Lewis explicitly told him he was violating her rights. She stated clearly that she did not consent. She identified herself as a federal attorney, and he proceeded anyway. That's not a split-second error in judgment. That's willful violation of clearly established constitutional rights. And willful violations destroy qualified immunity defenses. They open officers to personal liability. They expose departments to massive settlements. They create the kind of legal exposure that makes city attorneys panic. The legal framework governing Mercer's conduct was well established. Terry v. Ohio defined investigatory stops. Florida v. Royer clarified that airport encounters require the same constitutional protections as any other police interaction. Brenlin v. California confirmed that passengers have standing to challenge unlawful seizures. Every one of these cases was decided decades before Mercer put on a uniform. The law was clear. The training should have been clear. The constitutional boundaries were not ambiguous. Mercer chose to ignore them, and that choice would cost him everything. If police don't know where their authority stops, how can the public ever feel safe? Breanna Lewis stood in the VIP boarding queue with her arms at her sides, breathing carefully, forcing her professional training to override the anger and humiliation coursing through her. Officer Daniel Mercer was still standing in front of her, blocking her path, waiting for compliance that he believed was inevitable. Other passengers watched in uncomfortable silence. The gate agent was off to the side, speaking rapidly into her communication device. Security cameras captured everything from multiple angles. Lewis made a decision. She reached into her suit jacket pocket slowly, making sure her movements were visible and deliberate. She pulled out a black leather credential case and held it at chest height where Mercer and the surrounding cameras could see it clearly. She opened the case. Inside was her Department of Justice identification card bearing the seal of the United States government. Next to it was her federal prosecutor badge. Below that was her federal bar credential authorizing her to practice in federal courts nationwide. She held the case steady, her hand no longer shaking, her voice absolutely level when she spoke. My name is Attorney Breanna Lewis. I am a federal prosecutor with the Department of Justice's Civil Rights Division. I have spent 17 years investigating and prosecuting law enforcement officers for civil rights violations. I specialize in cases involving unlawful searches, excessive force, and misconduct committed under color of law. She paused, letting the words settle. You approached me without reasonable suspicion. You demanded identification without legal justification. You conducted a physical search of my body without my consent, without a warrant, and without any legal exception that would authorize such contact. You violated my Fourth Amendment rights. You did it deliberately after I explicitly informed you of the constitutional violations you were committing, and you did it in front of multiple witnesses while being recorded from several angles. Mercer's face had gone pale. His mouth opened slightly, but no words came out. His hands dropped to his sides. The aggressive posture collapsed into something closer to shock. The gate agent had stopped talking into her device and was staring at the scene unfolding. A passenger near the front of the queue whispered, "Oh my God." Another voice from farther back, "He just searched a DOJ lawyer?" Lewis closed her credential case, but didn't put it away. She held Mercer's gaze with the steady intensity of someone who had cross-examined hostile witnesses in federal court and wouldn't be intimidated by a rookie cop's authority fantasy. I will be filing a formal complaint with the Department of Justice's Office of Professional Responsibility, Lewis continued, her voice carrying through the gate area. I will be filing a complaint with the Miami-Dade Police Department's Internal Affairs Division. I will be filing a civil rights lawsuit under 42 U.S.C. Section 1983 for violations of my constitutional rights. And I will personally ensure that every frame of video from this encounter is reviewed by federal prosecutors who will determine whether your conduct rises to the level of criminal civil rights violations under 18 U.S.C. Section 242. Mercer took a step backward. His hand moved to his radio, but he seemed uncertain what to do with it. Call for backup? Report the encounter? Admit what he had just done? An airport supervisor was approaching now, alerted by the gate agent's call. A middle-aged man in a white shirt with supervisor insignia, walking quickly but not running, trying to assess the situation before arriving. Lewis turned slightly to address the supervisor as he approached. "I'm Attorney Brianna Lewis with the Department of Justice. This officer just conducted an unlawful stop and search. I need his name, badge number, and body camera footage preserved immediately." The supervisor looked from Lewis to Mercer, processing what he had just walked into. His expression suggested he understood immediately that this was not a situation that could be smoothed over with apologies and de-escalation. "Ma'am, I'm Supervisor Chun. I apologize for any confusion. Let me—" "There's no confusion," Lewis interrupted, her voice still controlled but carrying an edge now. "Officer Mercer approached me without cause, demanded identification without legal justification, and physically searched my body without consent after I explicitly informed him he was violating my constitutional rights. This isn't confusion. This is misconduct, and it will be documented, investigated, and prosecuted as such." Supervisor Chun turned to Mercer. "Is your body camera active?" Mercer nodded weakly. "Good. Don't turn it off. Return to the security office immediately and wait there. Don't speak to anyone about this incident except internal affairs investigators. Do you understand?" Mercer nodded again and walked away, his stride no longer confident, his shoulders hunched, the visible posture of someone who had just realized they destroyed their career. Lewis watched him go. She was still holding her credential case. Her hands had stopped shaking, but the adrenaline was still there, keeping her alert, focused, professional. The supervisor turned back to her. "Ma'am, I sincerely apologize for what just occurred. I want to assure you that this will be investigated thoroughly and—" "Save the institutional response for the formal investigation," Lewis said, cutting him off. "Right now I need you to preserve all video footage from terminal cameras, gate cameras, and Officer Mercer's body camera. I need his full name and badge number. And I need confirmation that he's being removed from active duty pending investigation." Chun nodded, pulling out his phone to make calls. The machinery of institutional response was activating, but Lewis knew from experience that without external pressure, investigations often died quietly in administrative review. This one wouldn't, because she had the expertise, the resources, and the determination to ensure accountability. The passengers in the VIP queue had been silent throughout the exchange. Now, slowly, boarding resumed. The gate agent called the first group. People moved toward the jet bridge. Lewis waited until her group was called. She boarded the aircraft, found her first-class seat, and sat down. She pulled out her phone and began documenting everything while the details were fresh: times, exact quotes, witnesses, the sequence of events. By the time the aircraft pushed back from the gate, she had already drafted the outline of her formal complaint. The flight to Washington would take 2 hours. By the time she landed, the first formal notifications would be sent, and Officer Daniel Mercer's 7-month law enforcement career would be effectively over. Why do some officers require humiliation before they recognize humanity? Officer Daniel Mercer sat in the airport security office, body camera still recording, waiting for internal affairs investigators who were already en route. His mind was racing through potential explanations, ways to frame the encounter that would make his actions seem reasonable, narratives that would transform what happened from misconduct into a judgment error, stories that would protect him from the consequences he could feel approaching like a storm. This is what happens in the moments after officers realize they've made a career-ending mistake. The instinct isn't accountability. It's self-preservation. The mind immediately begins constructing defenses, rewriting memory to align with justification rather than fact. Mercer wanted to believe he had acted on legitimate security concerns, that Lewis had been evasive or suspicious in some way that justified his intervention, that her refusal to immediately comply had forced him to escalate. But the body camera footage would tell a different story. It would show him approaching a woman standing calmly in a boarding queue. It would capture his inability to articulate any specific suspicious behavior. It would record Lewis explicitly stating that he was violating her rights. And it would document him proceeding with a physical search anyway. There was no reframing that would make this look good. Supervisor Chin entered the security office with another senior airport official. Their expressions were grim. They had already reviewed the preliminary reports. They understood the severity of what had occurred. Officer Mercer, you're being placed on administrative leave effective immediately, Chen said. Internal Affairs has been notified. They'll be conducting a full investigation. You're required to surrender your duty weapon and badge. You will not discuss this incident with other officers or anyone outside of official interviews. Do you understand? Mercer nodded. His throat was tight. This was real. This was happening. I was just doing a security check, he said, the words sounding weak even to himself. She was acting suspicious. Don't, Chen interrupted sharply. Don't make statements that aren't documented. Wait for IA. Speak with your union representative. But do not try to construct a narrative right now that you think will help you. The cameras captured everything. That was the reality sinking in. The cameras captured everything. His approach. His demands. Lewis identifying herself as a federal attorney. The physical search. All of it documented from multiple angles with audio that would leave no ambiguity about what was said. Mercer handed over his badge and weapon. The physical relinquishment of the tools that had defined his identity for 7 months. Without them, he was just a 25-year-old with no clear career path and a misconduct investigation that would follow him forever. He left the security office and drove home in a daze. By the time he arrived, the story was already breaking on social media. Passengers who had recorded the encounter were posting videos. Legal commentators were analyzing the footage. Civil rights organizations were issuing statements. The video showed everything. Mercer approaching Lewis without cause. Her calm responses. His escalation. The unlawful search. And then the moment she revealed her DOJ credentials and his body language collapsed. The comments were brutal. Thousands of people weighing in, most expressing outrage, some defending Mercer as a young officer who made a mistake, but the overwhelming sentiment was condemnation. By evening, national news outlets had picked up the story. Rookie cop searches DOJ civil rights prosecutor was the headline across multiple platforms. The irony was too perfect to ignore. An officer who specialized in prosecuting police misconduct being subjected to the exact behavior she had spent her career fighting. The Miami-Dade Police Department issued a statement. It was carefully worded, acknowledging that an incident had occurred, confirming that an investigation was underway, and emphasizing the department's commitment to constitutional policing. But statements don't undo video evidence. Attorney Breanna Lewis landed in Washington and immediately filed her formal complaint with the DOJ's Office of Professional Responsibility. The complaint was detailed, precise, and supported by video evidence. It wasn't a request for internal review. It was a demand for action. She also retained a private civil rights attorney to handle the federal lawsuit she would be filing against Mercer and the Miami-Dade Police Department. This wasn't about money for Lewis. She earned a federal salary. She didn't need a settlement. But she understood that without financial consequences, departments don't change. Trainers don't get replaced. Hiring standards don't get raised. Cultural problems don't get addressed. Institutional change requires institutional pain. And that pain typically comes in the form of massive settlements that force budget conversations that reach city councils and police commissioners. The internal affairs investigation proceeded rapidly. Mercer was interviewed. He had a union attorney present. The attorney tried to frame the encounter as a misunderstanding, a rookie error, an example of insufficient training rather than malicious intent. But intent doesn't matter in civil rights cases. The Supreme Court has held that officials can be liable for constitutional violations regardless of their subjective intent if they knew or should have known that their actions violated clearly established rights. Mercer should have known. Lewis had told him explicitly that he was violating her rights. She had cited the Fourth Amendment. She had refused consent, and he had proceeded anyway. That's not lack of training. That's deliberate violation. The investigation concluded within 3 weeks. The findings were unequivocal. Mercer had conducted an unlawful stop and search. He had violated department policy. He had committed constitutional violations. His actions warranted immediate termination. Mercer was fired. His law enforcement career ended before his 8th month on the job. And unlike officers who are quietly terminated and moved to other departments, Mercer's misconduct was now part of the viral public record. He would never work in law enforcement again. Do systems protect truth, or do systems protect each other? Attorney Breanna Lewis filed her federal civil rights lawsuit in the United States District Court for the Southern District of Florida. The complaint was filed under 42 U.S.C. Section 1983, the primary statute allowing individuals to sue state actors for constitutional violations. The defendants were Officer Daniel Mercer, individually, and the city of Miami-Dade County. The complaint alleged multiple violations. First, a Fourth Amendment claim for unlawful seizure and search. Lewis argued that Mercer had stopped her without reasonable suspicion and conducted a physical search without consent or legal justification. Second, a 14th Amendment claim for violation of equal protection. The complaint argued that Mercer had targeted Lewis based on her race, subjecting her to scrutiny and search that white passengers in the VIP queue did not face. Third, a claim of assault and battery under Florida state law. Mercer had touched her body without consent and without legal authority, which constitutes unlawful touching under civil law regardless of his status as a police officer. Fourth, a claim of intentional infliction of emotional distress. The complaint detailed the humiliation, violation, and trauma of being publicly searched by an officer who ignored her explicit assertions of rights and continued touching her body despite her protests. The complaint sought compensatory damages for the constitutional violations and emotional harm. It sought punitive damages to deter future misconduct. And it sought injunctive relief requiring the Miami-Dade Police Department to implement reforms in training, supervision, and accountability mechanisms. The city's initial response was predictable. They filed a motion to dismiss, arguing qualified immunity for Officer Mercer. The argument was that the law regarding searches in airport settings was not sufficiently clear for Mercer to know his conduct was unlawful. It was a standard defense. Qualified immunity has become a nearly insurmountable barrier in many civil rights cases, protecting officers even when they commit clear constitutional violations. But this case was different, because the victim wasn't a typical plaintiff. She was a federal prosecutor who specialized in qualified immunity litigation. Lewis' opposition brief was surgical. She cited decades of case law establishing that suspicionless stops and searches violate the Fourth Amendment. She quoted Terry v. Ohio, Florida v. Royer, and numerous circuit court opinions that had addressed airport searches. She demonstrated that the constitutional principles Mercer violated were clearly established long before he became an officer. She also pointed out that Mercer had been explicitly informed during the encounter that he was violating her rights. He had been given real-time notice that his conduct was unlawful, and he had proceeded anyway. That destroys qualified immunity. The defense exists to protect officers who make reasonable mistakes about unclear law. It doesn't protect officers who are told they're violating rights and continue anyway. The judge denied the motion to dismiss. The case would proceed to discovery. The Miami-Dade Police Department released the full body camera footage under court order. The video was 23 minutes long, capturing Mercer's approach, the entire encounter, and the aftermath when Supervisor Chen arrived. The footage went viral. Millions of views across multiple platforms. Legal analysts broke it down frame by frame on cable news. Civil rights organizations used it as a teaching tool in workshops on police accountability. The video was devastating to any defense Mercer might mount. It showed a calm, professionally dressed woman standing in a boarding queue being approached without cause. It captured her measured, articulate responses. It documented her explicit statements that Mercer was violating her rights. And it recorded the unlawful search of her body. There was no way to watch that footage and conclude that Mercer had acted reasonably. Discovery proceeded. Mercer was deposed. His testimony was halting and defensive. When asked why he approached Lewis, he struggled to articulate specific behavior that had raised his suspicion. He admitted she hadn't been running, hadn't been looking around nervously, hadn't been doing anything that would typically warrant police attention. She just seemed out of place, he finally said. Out of place how? Lewis' attorney asked. I don't know. Just out of place. In a VIP boarding queue? Yes. And what about her appearance made her seem out of place? Mercer hesitated. He understood where the question was leading. I can't really say. Was it her race, Officer Mercer? No. I don't know. Maybe subconsciously, but I wasn't thinking about race. The admission was damaging. Not because explicit bias would have been better, but because it revealed the truth about how racial profiling actually operates. Not through conscious hatred, but through subconscious assumptions about who belongs where.